In this lecture, we'll talk about the client-lawyer relationship. A client-lawyer relationship is formed by a mutual agreement between the parties. There needs not be a written contract or even a fee payment. For as long as the client reasonably believes that the lawyer is providing legal assistance or advice to them, that relationship is formed. It may start by a person or prospective client consulting a lawyer with the intent of obtaining legal services or representation. The lawyer agrees to those services, and the person or prospective client reasonably relies on the lawyer's conduct. The formation can be explicit, implied, reasonably by reliance of the clients to the lawyer. An example of an explicit relationship is a lawyer signs an agreement to represent a client. Implied, a person asks legal questions and the lawyer answers them, leading the person to reasonably believe they are a client. No formation takes place when a lawyer gives a general response that they can't help the client with a certain legal issue, or when the lawyer disclaims representation clearly. In a nutshell, a lawyer-client relationship is formed when a person seeks legal advice, the lawyer gives the legal advice, and a reasonable person would believe they are being represented. A relationship is now formed when a lawyer clearly declines representation, or no legal advice is given and the lawyer conduct does not imply a relationship. No written contract is required. A reasonable reliance by the client can be formed, and even prospective clients are protected by Rule 1.18. And once a relationship is formed, ethical duties attach. The clients with diminished capacity, the lawyer must maintain a normal client-lawyer relationship. The duties and considerations are to treat the client as if they were a competent adult. The lawyer must not automatically substitute judgment or overrule their decisions. The lawyer must presume capacity unless clearly stated otherwise. Protective actions. If the client is at risk of substantial harm and cannot act in their own interest, the lawyer may take protective actions, such as consulting family members, using adult protective agencies, and in extreme cases, seeking appointment of guardianship or conservatorship. Confidentiality still applies. The division of authority between a lawyer and a client is twofold. The client decides the objectives of the representation, whether to settle a civil dispute, whether to plead guilty in a criminal case, whether to waive jury trial, or whether to testify. The lawyer, however, decides the means of the objectives, which motions to file, what legal strategies to pursue, and which witnesses to depose. Their relationship, lawyer and client, is made in the sense that the client's control of the major decision making that affects their rights. The lawyer controls the legal execution of those goals. A representation of a lawyer to a client is not an endorsement. So that means that the lawyer must not counsel or assist a client that the lawyer knows is using the lawyer services to commit criminal offense, such as a crime or fraud. The lawyers, however, may discuss the legal consequences of the action. Lawyers may refuse to carry out client's direction that are illegal or unethical. The lawyer can limit the scope of representation to a client if that limitation is reasonable and the client gives informed consent. Here are some MPRE rules or clues that you can look at for your preparation of the bar exam. There are two types of authority in a client-lawyer relationship. We have actual authority, which can be expressed or implied. And express actual authority is a situation where client directly communicates to lawyer that the lawyer can negotiate a settlement for up to $50,000. Implied when the lawyer, during his representation, carries out certain actions such as filing motions, contacting witnesses. Apparent authority is when a third party reasonably believes the lawyer has authority to act based on the conducts or the client's conduct. And this comes from agency law. And the lawyer lacks actual authority. If the lawyer lacks actual authority, if a client allows the lawyer to appear authorized, the client may still be bound by the lawyer's action. Therefore, the lawyer must not make decisions without the client's consent. Counsel and assistance within the bounds of law, that means that no assistance is permitted in crime or fraud. So the lawyer needs to refrain from any assistance or any counsel that will allow the client to engage in a crime. However, the lawyer may discuss the legal consequences of any proposed action and may help the client understand the law. So, what is allowed? The lawyer is allowed to advise the client about the law, to warn the client, to help the client comply with the law, and to explain the consequences of their actions. The lawyer is not allowed to assist the client in perjury, fraud, or illegal conduct, or to help the client in actions that involve money laundering, tax fraud, or illegal evasion, or preparing documents or giving instruction that enable client to commit fraud. If a lawyer discovers that the client is using their service to commit fraud, the lawyer must withdraw. The lawyer may reveal information to prevent or rectify harm, or the lawyer may reveal confidential information to the extent necessary. Now, in our next lecture, we will be talking about termination of the client-lawyer relationship. I'll see you then.